All right, Ronnie, thank you so much for joining us here on the Read Report. I'm Nicole Ryan, I'm your host, and I wanted to get started here. First and foremost, thank you so much for agreeing to speak with me. This is huge. I'm so excited to have you on the Read Report, and I know all of my listeners will be as well. So, first, if you want to just introduce yourself for the audience, that would be great. And then we'll get into some questions if that's cool.
Okay. So thank you for having me. Pleasure to be here. And my name is Ronnie Estanislao, and I was one of the jurors on the original or initial Karen Reed trial.
Yes, thank you, Ronnie. So you want to talk a little bit about your initial experience when you found out that I got jury duty and then you wound up realizing that it was this crazy big case. How did it all come about?
I received a notice for jury selection, and I called the night before because it said call the night before just in case it was canceled. So I called the night before, and unfortunately, they said, no, it's not canceled. Drove to Dedham and got there at the courthouse. And one of the first experiences was there was a lot of people. And maybe it was just me being naive, not realizing what was going on, but it just seemed like there was a lot of people there. My plan was to go there, and there's a nice Thai restaurant in Norwood. So my plan was to go in, and then usually you spend the morning there, not even the whole morning. And then afterwards you're able to go and have lunch somewhere. And that was my plan for that day because I said, I've got jury selection, I have to go. And that's what essentially I was going for. But it turned out, no, that wasn't the case. It would be much longer, spending most of the day going through hundreds. It wasn't all 100 people, but it was a large grouping of people in a small room initially, and then ultimately going into the room in front of the judge to ultimately be selected as one of the jurors.
Did you have a hunch that you were going to be selected after those initial questions from the judge? What
I
was your
was
initial
trying to
sentiment?
actually get out of the whole thing just because I thought that it would be more of one of those drawn out, and I really didn't know the time commitment and what was the responsibilities that one had to perform in order to be a juror.
So certainly you realize, okay, this is not my typical day of jury duty. Looks like I'm going to be sticking around. At what point were you like, holy cow, this is a big case?
It was early on. So the first part is you're in this big room and you watch this video, the standard video for a jury. And they usually say, oh, in the afternoon, there, depending upon what's going on in terms of the cases, you'll be released if nobody wants to go to trial. And so that's how it was initially introduced. And then afterwards, then we went into the courtroom. We were actually told that no, we are not being dismissed. Not one person would be dismissed. And then we went into the larger courtroom for the selection process. Now, part of it was some individuals were already disqualified because of their answers to the questions that you had. So initially, when you walked in, they collected a piece of paper where you answered some questions. And for the most part, most people, right, you were truthful. I was truthful in trying to say that I have a daughter and essentially I work as a healthcare provider, as a paramedic, and all of these things. And I also even disclosed that at one point in time, I was going to be an FBI agent. But anyway,
So cool.
hoping that all those would ultimately lead to this. Okay, you're no longer qualified or you're disqualified as this, right? But that wasn't the case. The first round, they dismissed certain people. And it was very interesting. One of the questions that everybody got asked was, have you heard about your case? And of course, I think it's very hard not to have heard about the case. watching the news, the newspaper, anything, media. And if you're from the South Shore, you would have heard something. You might have, don't know the specifics about the case, but you knew about the case or something about it.
Definitely. And you mentioned that you are an auntie, and how did that experience translate into the way in which you viewed certain people's testimony, the way in which you viewed certain evidence? How did that come into play, or did it?
So one of our charges as a juror, and the judge was pretty adamant about this, was not to utilize some of our information, but really as based on our experience, but more to look at the full picture and allow the evidence to talk for itself and not to be biased in any way, shape, or form. So it did provide some sort of information, given the fact that I have that experience, to try to relay that information to the other jurors who may not have that experience, but not to in any way, shape, or form lead them in one direction or the other, but rather just give them the facts so that they could make an informed decision.
Taking a step back from how you were looking at it in the legal sense, trying not to apply your own bias into this specific case, were there any experiences just in general that reminded you of, like, when I was an EMT and I did this, or I responded to this specific scene and it reminded me of these injuries, or did anything like that kind of occur that just is in your head in retrospect, or just stepping apart from evaluating it as a juror? Did you have
I,
any experience there?
I think the first part was we really talked about it, and there was three of us who were in healthcare specifically. And we also pointed out or recognized that when a patient does come into the emergency room, the cleanliness of the emergency room is not always 100%. Therefore, there can always be cross contamination of material
Mm,
on that floor. And again, I don't know when John's clothes got caught, but essentially there could be contamination on the floor of the ambulance. There could be contamination on the floor of the emergency room. And it was not very clear when they were talking about some of the sample and the contamination of those pieces of evidence, whether or not they directly linked it to the motor vehicle, so the tail light pieces and other pieces. So you could think about that. And then they think the other thing that kind of hit a chord, was when people, in terms of their testimony, first responders in terms of their testimony, were very specific on the verbiage, even though it wasn't on camera or recorded, that they were very specific about the verbiage that was being used by individuals. And in the heat of the moment, I think I would focus more on the resuscitation of my patient, and not necessarily the verbiage of someone, and knowing full well that law enforcement is there, and law enforcement, that's their job to pay attention to that verbiage and document those pieces. But my job as a first responder would be to focus on the resuscitation effort of my patient.
yeah, that makes sense. Definitely prioritizing patient care is super important in any sort of first responder role. And I think that makes sense. And having that perspective also helps enlighten you about that specific reactions of paramedics who responded to the scene. Were there any specific testimonies or pieces of evidence that kind of changed your mind, or this like big mic drop moment for you, or anything that really just had you stopping in your tracks?
I think the biggest piece was the video of the group exiting the waterfall. And I think when they exited the waterfall, it showed that John was actually holding a glass. And nobody actually highlighted that necessarily. but that kind of showed to me that he was still drinking, right? And
Right.
I think everybody's drinking, right? And I don't know if anybody should have been operating a motor vehicle during that time frame. The other pieces that were significant was the the revelation of the text messages that Trooper Proctor was sending out. That was disheartening and very unprofessional, and it gave you a light on what type of behavior may be going on in any aspect or any kind of job, but hopefully it shouldn't be pervasive in the law enforcement role. And then the individuals that were gathering evidence. So from the initial evidence collection by Canton PD solo cups and using a leaf blower to, right, having somebody testify from the state police who does not seem to have any knowledge of physics.
Right.
So not very clear. Or even if they did not, I would think that you would pick up a book knowing full well that you're going to testify tomorrow to at least have some sort of semblance on force and physics. And then from the testimony of the different individuals to include ARCA at the end to give us some data. I think it was sad that we did not know that ARCA was specifically as part of another investigation. I think it was confusing for the jury because the jury was torn on whether or not this was just a distractor that May Karen Reed's lawyers had hired them specifically, or this was insurance that was doing it, or what was their real purpose to try to testify. It would have been nice if there was some reenactment or some graphics showing maybe how it could have happened. It would have been nice.
Definitely. And you brought up ARCA. I know you've probably been seeing the news lately and you've seen the latest developments on that and more to come. We don't know everything yet. Given what you've seen, does this kind of change your opinion? I know originally you've been not guilty on definitely 2 out of 3, and then the third, involuntary manslaughter, which you guys were hung on, you were one of the not guilty voters on. You swayed for a second, then you came back to not guilty. Given the recent development with ARCA and then given the other news about Karen Reed, where it was like saying maybe the federal investigation is over, we don't know if this is confirmed yet. We don't know if any of this is really confirmed yet. What are your thoughts as to what's come out recently, what might still come out, and does it change anything about the case, how you handled the actual trial, or does it change anything about what you think going forward?
I think what's interesting is to be able to see the system at work. And I think having that, it's unfortunate that we have to result in having to redo this in terms of closure for everybody, Karen and everybody's families, well as the resources that have been placed, right? Money and resources and time for this whole thing. I think it would have been nice if it was very clear that we could have looked at each charge individually, and that by looking at each charge individually, we would have at least addressed 2 of the charges and would have come to unanimous conclusion for those 2 charges. The last charge, I don't know if we would have continued to deliberate that last charge longer, but that being said, by looking at all the different pieces of information, I think that's the other thing that the public doesn't understand. And that is we can as the jury, we can only look at the specific testimony that is actually approved by the court and then also only look at the testimony that is provided to us and the evidence that's provided to us. So we don't have the luxury, like most of the public, to go home and Google anything
Mm.
and do our own separate investigation. And I think with that, I would still think that it would be pretty similar for result. I don't think the current jury, the new jury would do kind of change. I think it's going to be exactly the same for at least two of the charges. The last charge, or the middle charge that everybody talks about, the involuntary manslaughter. I don't know if that would sway them after more deliberation, given this new evidence and given these new parameters to try to testify whether they are going to arrive at a conclusion. I hope they will, because I think it would be unfortunate again if they come up with the same conclusion and ultimately again be a hung jury. So I hope that's not the case, but I don't think it would change anything for me in the way I would vote. But again, because it's a jury, it's 12 individuals that have to agree on a decision, which I don't know if that would have swayed anyone in one direction or the other, given the
Exactly.
circumstance.
It's a challenge in and of itself to get 12 random people to agree on anything these days. So you bring up excellent points. It's tricky because the way the legal system works is you guys are given this specific set of testimony, specific evidence. You asked for the cert report, right? And they told you guys have what you need. Going along with that, how did that question arise? Asking for that additional piece of evidence.
So we were asking for a lot of the reports because we were trying to establish, based on evidence, a timeline if there is any possibility that evidence could have been planted. So the thought process that the tail light was broken in the Sally port and then ultimately then distributed essentially on the garden or the lawn of Fairview. So I think that was one of the pieces that we were trying to look at. The thing with the camera footage in terms of the library and trying to figure out whether or not we could discern if the tail light was already broken or significantly broken at that time as she traveled back and forth. So I think those are pieces that we were looking at. We also wish that there was more testimony from the Dighton police officer, clearly indicating whether or not how much damage, because in his testimony, he said it was a crack, but we don't know, right? It would be better a comparison or this versus this, right? In terms of what the tail light looked like when he approached it and saw it, as well as when the tow truck driver came there to Dighton to remove or transport the vehicle. It would have been nice to have his testimony his or her testimony. We just assume it is. And then also the whether they notated anything, whether they took pictures or notated anything. Because usually when you transport a vehicle as a tow truck driver, usually you take some notes or you take some pictures so that you can prove that the damage was pre-existing prior to you moving the vehicle. And then also that there was no new damage after you moved the vehicle. So I think those little pieces would have been nice to actually have.
Sure. And that charge that you guys were actually hung on, the involuntary manslaughter, what pieces of evidence were some of the stronger opinions in the room bringing up that um, made them convinced that maybe we should find her guilty of this charge?
So I think there was some of us who were stuck on the fact that the ultimate cause of death was a skull fracture and hypothermia. The skull fracture was essentially at the base of the skull. So it's very difficult to show the physics on how somebody backing up and the damages to the vehicle seem to be inconsistent for a broken taillight to demonstrate that the individual, the victim, would ultimately have a basal or skull fracture and then die of hypothermia. Now, that being said, one of the pieces that we all arrived at was, number one, John was the one who was really intent on going to that address. And some of us felt that Karen wanted to go somewhere else. I think, I don't know, but perhaps to eat somewhere or to ultimately just go home. But he was adamant and he programmed the GPS there to go to that location. In fact, even calling Jen how to get there. What really made the jury arrive at the conclusion that, and this is where we were divided, is that there was both individuals, Karen and John, were there. They drove there. Karen was operating the vehicle. There's a broken tail light, and ultimately John succumbed to his injuries on the front lawn of the house, and everybody in the house claimed that he never entered the house, and everybody claimed that he was never seen inside the house and never came in. So some individuals arrived at the conclusion that the vehicle was there. Karen was operating the vehicle. John succumbed to his injuries at the front lawn. She must be responsible for involuntary manslaughter because she was operating the vehicle under the influence of alcohol.
Mm-hmm. And why her vehicle specifically in that situation? Obviously, there's evidence, but I'm just curious to hear it in your own words.
It was the combination of the data that they were showing. There was some sort of acceleration, deceleration. And then there was also the information that there was broken taillight as well as broken taillight pieces on him, on his clothing, which
a lot of people don't know that. And some of them were like microscopic, I think.
Correct. But I think that's the other piece that's interesting. Even though they're microscopic, then you have to wonder like how that came upon his clothing.
Definitely. And what was the train of evidence collection that led to said pieces of clothing?
That's also I think it was very clear that the initial evidence gathering and preservation of the crime scene was not as professional and well done as we would like it. I think retrospectively, everybody was thinking, you know what, they were doing the best that they could, given the circumstances. It is a snowstorm, right?
Certainly.
Like, you don't have the resources, you don't know, you don't have the training, and therefore maybe that's why it ended up in that direction. I think it's unfortunate that they didn't seek more resources. And I think it's also unfortunate that we live in the Northeast. So you can't say we don't know, we're not familiar with trying to deal with blizzard-like conditions.
Good point.
And preserving evidence and evidence collection and preserving a crime scene versus, I get it, if we were in a warmer state and all of a sudden we had a snowstorm, that would be totally different.
Exactly. And in terms of the actual pieces of taillight, how often did the discussion of the taillight come up in deliberations? And was it something that people felt extremely strongly about in terms of one way or the other.
I think
Was
the
her
two,
taillight broken? Or,
yeah, the two pieces that everybody, I think one was the distractor, right? So the distractor was they were trying to indicate that there was an impact of Karen's car to John's car at his driveway at one point in time, and that may have caused damage to the tail light. So that was that one piece, which was the distractor. The other parts is that the question discussions were on whether there was thought of the taillight being broken in the Sally port and then ultimately being planting of evidence potentially on the lawn of Fairview. And then after that, once that was dismissed, basically, that was not the case based on what we were trying to conclude in terms of timeline. Then it moved to now, okay, there's broken taillight, in the lawn, and there's pieces on John's clothing. That must be a point of impact. Again, it's not very clear if that is ultimately was the cause of death, but it could have been a possibility of what ultimately caused him to get his skull.
certainly. What about the glass pieces? Is that something that you guys talked about? Or how did the glass come up in the deliberation process?
I think we kind of deliberated that in terms of how do we expect the glass and how did it break? There was a theory postulated during deliberation that perhaps John actually threw the glass and that impacted the tail light. If he does throw it with enough force and also the speed of the vehicle, could that have actually caused pieces to actually end up on his clothing still? And ultimately, due to his inebriation, that he may not have the best balance after throwing glass, which ultimately could have caused him to fall backwards
Mm,
and hitting his head onto the right
yep,
frozen ground. So that is a possibility. Again, there was no physics. We weren't right. We were not told to come to our own conclusions, but just follow the evidence. But we talked about it. That is a possibility. But
yeah, that's definitely an interesting point. And I think there are pieces of this case that get left out in a lot of senses and some people's retelling and like the court of public opinion. It's just there's a lot of evidence on both sides, and I still don't know what happened. I don't think we're ever going to fully know what
I
happened.
don't think so.
I love the case and I love to hear both sides. And I think it's important to give it a fair shake and definitely brought up some things that I hadn't even considered. I think that's why it has this kind of evergreen, like mysterious and enticing nature to it, right?
I think it's also interesting. So the two other interesting pieces was the text stream data that they had. Nobody could actually say, or I wish there was more of an expert to be able to testify regarding how accurate it can be. For example, I think there was only a number, and I don't know I can't recall the exact number that they were saying of events on Karen's vehicle. If she is operating that vehicle, what can cause it? What are the triggers? And so in like the other day when we had the snowstorm and the ice storm here, could there be triggers on my vehicle or your vehicle?
Certainly.
And would that necessarily mean that I tried to accelerate or decelerate? Maybe I tried to accelerate because I was trying to regain control of the car when it is icy and slippery out, which you can imagine you could potentially hit the accelerator, you could potentially hit the brake. Who knows how you may try to handle that kind of situation.
Yeah, definitely. And just the evidence itself and the process of evidence gathering at times, just thinking from my own perspective, I don't really want that to be why they convict me. It definitely leads me to be very wary of the whole process. And I think anybody can see that regardless of what they believe about this case or don't believe about this case. What do you think about the murder charge? Because I know obviously for you, you're like, no, not guilty. It's crazy, right? That was even a charge in my mind, but was there motive there at all from anybody's perspective?
I think the motives might have been, and what they were trying to look at was a couple that was having some issues, and trust issues, for lack of a better term, is what it seems like it on both sides, right? And I don't know if there was anything on John's side because I can't testify to that. But what we do know is that it seems like what they were trying to show is that might have been a motive that Karen was trying to purposely injure John. That being said, I think there was enough to create reasonable doubt. And unfortunately, again, it needs to be all 12 have to agree with the same kind of verdict. But at the same time, it does create that reasonable doubt to make that hung jury again. But in that particular charge, I think it was very hard, or it was a reach to say that she purposely wanted to do it.
Yeah. So what did you make of the voicemails when they played those for you guys?
I think for them, so again, because it was divided as a jury, but for me, listening to it, it shows that somebody who probably is a combination of stressed, worried about somebody's loved one, right? And then also still intoxicated. I cannot imagine if you are under the influence of alcohol, you are very thinking well. And I think that may have played into it. And what was going on in the weeks prior to the event. So I could just imagine that would be maybe somebody's recording something, you're not expecting it, you're under the influence, you're stressed out, you've been having these kind of disputes or kind of arguments. I could see how words may be said and
Totally.
emotions might be high.
Yeah, we all argue with our loved ones, right? And then also to hear it in the context of everything else that was going on with them, and then the Higgins character, and then we've got just underlying jealousy, it seems, perhaps. We don't know. Obviously, it's easy for me to sit here and judge Karen Reed's relationship because it was on display for everybody else. If everybody else had their bad laundry out to air, I'm sure everyone would have something to say about our relationships or our past. But I think something that I've said jokingly, I watch a lot of Dateline. Do you watch Dateline?
I used to, so it's funny you say that because before the case, I would always watch like CSI and NCIS, and which is not realistic, or a little bit, but maybe based on some real cases. And then I would watch Forensic Files and Dateline on a regular basis. So it was very interesting being on the other side and actually living it.
Totally. That is so cool. Yes, I love Dateline. And I guess one of the things that kind of made me think of Dateline in this case is you hear sometimes husband kills wife, right? Husband calls wife's phone after he knows he already killed wife. Husband says, "Hi, honey. When are you going to be home,
Right.
sweetie? I miss you. I love you." That was not the case with Karen Reed's voicemail. That is like
Never,
the
right?
worst sort of voicemail that you would want to leave, right? So
Like
definitely that was
it could be
interesting.
damning. It could be very like bad evidence if that were the case. Yeah. It's
Totally.
very
It's
interesting.
something totally weird. Going back to the case itself, when you were in the courtroom and you were listening to these different testimonies, you're having these long days, you're trying to just come home, not look at the news, go back, rinse, repeat. There were times where you guys had long breaks between, like a long weekend, or you had holidays, a couple holidays that came up. Was it hard to remember what happened beforehand? Were you taking a lot of notes? How was that?
So one of the major charges was by the judge is that we would not talk or discuss the case, right? And it was very explicit every single day, not talk about the case. And then at the beginning, when we would walk in, she would ask again, did anybody talk about the case so that it could be discussed so that potentially that individual may be dismissed as a direct result of, right, information that was gathered outside of what was important or necessary. That being said, we would remember because we took notes. So one of the things as a juror, I didn't know this. I have no background in law, but you have a notebook and you're asked to take notes based on testimony. Obviously, you have to pay attention on the testimony. It's only done once. It's not recorded. So whatever you write down is what you're going to be able to deliberate with in the end, in addition to being able to see the pieces of evidence that they do present, pictures, video, any of the tangible pieces of evidence, broken tail light, broken glass, those we are able to see. But other than that, most of it is done by our notes.
Mm.
I think that's one thing maybe I would emphasize for anybody who would be on a jury, to be very good at taking notes and also making sure that you are able to either categorize it so that you're able to find it easily. Because if you have pages upon pages of notes and you write pretty much paragraphs, then it's going to be hard for you to try to look for those notes during deliberation. But if you categorize them or tab them out or something, that may be helpful. But that's how we recalled everything during deliberation, is we were able to look back at our notes, even though we had these breaks, these long breaks at time.
And the exhibits, so did you guys get like a giant packet of all the evidence, like the different exhibits, photos, videos that were shown to you, or how did they present that? So I'm curious.
It was a combination. If anybody was in the courtroom or saw, when they were referring to the evidence, they had categorized it by number and some sort of identifier. And so they placed it usually in a binder, and those binders where we could reference these pieces of evidence or exhibit. The larger pieces, right, were in boxes. And so literally we were given these boxes of binders and boxes of exhibits or evidence, material evidence that we could look through, inclusive of clothing, inclusive of all the exhibits that were presented during the case.
Any pieces of exhibit just keep coming up, or did you guys stare at one for a long time?
I think the taillight was one that came up a while, and then also some of the videos. So some of the videos we asked to look in more detail with the Sally Port video. I think there was this question on whether they were trying to be truthful when they first presented the video, and it turns out that it was actually inverted. But we dismissed that early on as maybe just a mistake, an honest mistake.
Interesting. And then I have to ask, because I know other people are going to be wanting me to ask, but like in terms of any of the Albert's testimonies or just any of the McCabe's, were there any specific testimonies that you were, this seems sketchy? Brian Albert, Brian Higgins, both getting rid of their phones. Is this sketchy? Did you put weight to any of that, or were there any things like that made
Again, depending upon each juror had to take that into consideration. I think the interesting part of it was it is very sketchy, right?
Yeah.
I don't know. I honestly would not know to remove the SIM card and dispose of the SIM card. I have a bunch of phones over the years and have changed and upgraded. I don't know if I could. It must be like everything has aligned for me to realize to change it right before I'm going to have a subpoena to, right, somebody to take custody of my phone to look through what I have on my phone.
Right.
And then the other piece about it is I think all the phones that I've had in the years that I have changed my phones, I still have the phones in a drawer somewhere. I don't think I've ever even thought of disposing of them. I think I considered maybe donating it, but again, I still have most of them. I don't know if I would have done that coordinated once.
Mm.
Their testimony, all their testimonies were seemed a little too scripted. So I think if you're trying to recall some information, each individual may not have the same exact data points or pieces of information to the T. This seemed like it was very, at least to me, very scripted. Like they had scripted they talked about it, they took notes and said, this is what we're going to say. But I
Mm.
don't necessarily think that says there was any, that they were trying to be devious about it.
Right. And it could perhaps have been, hypothetically, because of other testimonies that they had given, that there were other proceedings that they had to testify for regarding this incident, right? I think that's another possibility, but definitely I could see why it comes across like that. And I could see why people were maybe comparing it against their own experience, but then also being like, okay, wait, this is also, they did get some sort of subpoena, or they knew they were tipped off that they were going to get some sort of subpoena, and they thought that they needed to get rid of it. Who knows? It's law enforcement too, which, like, not to say that I don't 100% trust all of my law enforcement officers, but there might be other stuff that they're hiding too, right?
Right.
Did
Who
that
knows?
sort of come up in your mind too? Yeah,
There might be
potentially.
something personal that they're trying, right? So granted, it's their phone, so it's
Mhm.
their own personal phone, but it was very interesting that there was group chats, right? And
Yes.
the entire group chatting about the same thing
And when
in
you
one
say the
specific
entire group, you
family.
mean McCabe's and Albert's being like, tell them the guy and everyone in the house, that sort of
Correct.
thing. Yeah.
Correct.
What about, speaking of other group text, what about the Proctor group text with his boys?
I think that text was, I was surprised. I can see it happening, right? So EMS, similar, right? Not appropriate, right? Totally not appropriate. I think it was interesting in that it actually was discovered,
Mm.
right? I don't know if that would be a normal thing. I'm surprised it got discovered and ultimately disclosed, because usually you would think that they would not disclose that, but they did disclose it. So it gives some light that says, okay, we can trust the system that regardless of the circumstances, however bad it is, they are going to disclose it and people are going to be held accountable for their actions. I don't know if it's going to sway. I think it clearly could sway some individuals in one direction versus the other, because it shows that it could have been just the entire evidence collection and the presentation is biased.
And what about the relationship component of things in terms of, okay, Proctor knows the Alberts, Proctor knows these people. Was it hard to follow? There's so many different, we've got people who are just like so into the case that they've just made these crazy charts. And they're like, this is an org chart of relationships with the Alberts and Canton PD. And like, how did you follow that? Did you follow it? What was that
It's
like?
like an algorithm. I have to admit, as part of the jury, it was very hard to create this diagram, because we are only able to take notes while we are in the courtroom. We leave the notebook there. We leave the notebook there overnight, and then we only pick it up again at the very end. Obviously, whenever we're there during the day. But when we go back for lunch or we are dismissed for the day, we don't have access to that notebook. And then ultimately we are able to look at the notebook again during deliberation. So that's why I was saying that it would be important to make notes or tab certain areas where you think there's pieces of key testimony.
Did you do that?
I did not, because I'm looking at it retrospectively. There were some people who were really good at taking notes. So I have to admit, I took decent notes. Some people were too detailed. Some people were not. And then I think the other problem is you have to pay attention whether it's in terms of an objection, if it's overruled or sustained, because if it's overruled versus sustained, you either have to cross out whatever you just wrote or not, depending upon the circumstance.
Mm, yeah, that's definitely confusing. There were a lot of objections throughout the whole course of the trial. Was there any specific jaw drop when people were realizing that Proctor was sending these texts? What was that reaction like among members of the jury, just to Proctor's testimony?
I think Proctor's testimony was just one of those where we all, based on the text message, at least I can say that he lost credibility as soon as that was revealed. So all of his testimony, granted, it wasn't a lot, right? It wasn't a large piece.
And which text message specifically? Because there were a few.
I think all of them.
Yeah, fair enough.
I think all of them were just crass that, it just clearly indicated that he wasn't as credible as a witness.
Can you tell me about your bow ties? Because I know that we're known as the bow tie guy. You want to tell the audience about your bow ties and your choice to wear one today, too.
So I used to wear ties a lot, and I learned to tie a real bow tie. And so I think I got hooked on it. So I tried to, when I first came on to the jury, I said, I'm going to wear a different bow tie every day.
I love it.
I didn't expect the case to go as long as it did, so I actually had to purchase some new ones. And
Did
then
they reimburse you?
no. But essentially what I ended up also doing was recycling some of them. I don't think anybody recognized that I recycled any, but I think it's nice to have a bow tie. It's different and is unique. So
Definitely. I love it. And I love that's like the distinguishing factor about you as a juror specifically, too. And that you brought it back for the read report. So about the deliberation process itself, take me to end of the trial, if you will. Like, you've got closing arguments. You're told that closing arguments are not evidence, but that's what's ingrained in your mind right before they give you the instructions and cut you loose. What was that like?
I think we were excited, for lack of a better term, to get to work, because the entire time we were just listening and taking notes and taking it all in. And now it was time for us to settle down and get to work and really deliberate and discuss everything and come to a conclusion on 3 charges.
And that courtroom itself is pretty small, right? Was it intimidating to A, know that you're making a decision about someone who's right in front of you, and B, also see other characters who have testified staring you guys down during this, and also the O'Keefe family? What was that like to be right up close and personal with these people and then to hold the fate of the case in your hands?
I think I will admit, I think the word intimidation is a little too strong. I think it's in between intimidation and overwhelmed with your current responsibility in your role, and overwhelmed by everybody kind of staring at you, hoping that you will come to some sort of conclusion on whatever is charged. And so the 3 charges, or what you're charged with. So I think that's essentially what was going through most of our minds, is that here we are, we're going to do this. And at the same time, culmination of weeks of testimony.
And what was the initial first day of deliberations? Did you guys do any polls? Did you just talk through it? Did you not really talk about it initially to
I
ease
think
into that?
I'm not, I don't recall exactly if it was day one or day two where we ultimately had a poll, and we came to the conclusion that there was a couple of charges that we already started to agree on. And so it was very interesting. I think we ultimately, how we came up with it is that we wanted to look at all the evidence to make sure that we gave them fair opportunity to glance at everything and do a proper deliberation as opposed to just make a fast judgment.
Gotcha. And as the days turned into another day and another day, were tensions high in that deliberation room? What was it like?
I think it became heated at times as our personalities and our beliefs were starting to show, and our level of expertise in terms of some individuals good in science and in physics, providing opinion, as well as looking at the evidence and arriving at conclusions. I know that we read the charges multiple times, trying to make sure we understood the charges very clearly and that each juror could vote on the charge and have an understanding of what the charge was. So we were really trying to do our best given the circumstances. And like I said, I wish that we had asked the judge clarification on whether we could vote on each charge independently.
And you made reference to personal beliefs and different personalities and different expertise. Those notes that you passed the judge, or the foreman passed the judge rather, they did at times reference personal beliefs. Tell me a little bit more about how that specifically impacted the deliberation process and what you mean by personal beliefs.
Each individual would provide their own thoughts on looking at the evidence. And that is essentially what played in what they voted or how they voted. Some were more vocal than others, and some were very rigid and not able to bend. I think one of the other things that the public does not understand is at the end, you try to have everybody look at all the evidence and try to get everybody to go in one direction or the other. And I think that's what a lot of people don't understand. At one point in time, it was very clear that certain people were not going to budge. And those are the beliefs that could not have been changed given the circumstances and regardless of how much more time and effort and deliberation would have occurred. Those beliefs were such that they could not be changed. And therefore, that's why it ended up as a hung jury.
Do you think they couldn't be changed because just how strongly people believed in certain elements of the case? Or do you think it was also just like this notion of somebody has to pay for it? Or was there any sort of rationale that accompanied that rigidness?
I don't think we went into too much detail to ask each individual how or to explain themselves on how they were voting per se. It was just based on their belief that the evidence is showing that this is how they should vote. And we no longer question them given the circumstance. Yeah. I think it would be different, and this would be a different discussion if we were talking maybe like one, right? I think 12 Angry Men, right? Famous, right? Movie. I think it would be different, but because it was initially so divided, and ultimately started to sway in one direction. I don't believe, and I know that ultimately it didn't happen, that we could not arrive at a conclusion that we would unanimously vote for guilty versus not guilty.
And one point, you did change your vote to guilty in involuntary manslaughter charge. Tell me about that rationale. Were you trying to achieve the objective of everybody voting on the same thing and just get it over with, or not actually get it over with? But like, how did that shake out?
It was interesting because I thought about it, and the argument or the deliberation was they should have not been operating a vehicle. And ultimately, John O'Keefe is dead.
Somebody lost their lives.
So somebody lost their life. Involuntary manslaughter, right, as a direct result of operating a vehicle under the influence of alcohol. Now, it's different if there was some sort of damage to the vehicle indicating that is ultimately what killed Mr. O'Keefe. In my opinion and in my belief, the damages to the vehicle and the injuries to Mr. O'Keefe were not consistent with an impact of a motor vehicle. Therefore, you can't say that yes, there's damages, but there's no, right, direct causation that you could indicate for him to have died as a direct result of an impact. That's why I was torn, because I know people were saying she was operating a vehicle under the influence of alcohol. There's damage to the car. He's dead. He has injuries. She must be
Sure.
guilty of that charge. And it's a lesser charge. But then you would have to fall back and say, then we would have to find her guilty of leaving a scene of an accident, right? So it became one of those where some people were very adamant about it, but at the same time, when you say you're adamant about that, then you have to question the last charge, which is leaving a scene of an accident, right?
When you all sent back that first note where you were just, we're stuck. I don't know what to do. We feel like we just aren't going to get anywhere. And she sent you back in initially. Were you guys going, come on? Or what was that like?
It was interesting because for the most part, everybody wanted to look at the evidence again. So we looked at videos again. We looked at the shirt. We looked at the tail light. We looked at evidence again that first time around. It started to break down in time, because I think at one point in time, it was clear that, like we talked about before, there were some people whose beliefs were set and could not be changed. And when we realized that, I think is when Foreman very eloquently wrote in the letter or the note that there were some beliefs that could not be changed, clearly indicating to the judge that we were at a stalemate and that there would be no resolution to try to go in one direction versus the other, despite any more time and effort with deliberation.
Did you assist with writing that note, or was that something the foreman, for the most part, came up with on his own? Or?
The foreman was very eloquent, and he was the one who was really doing the writing of the notes. And we were just in agreement based on what he had put together. I have to admit, for the most part, I was one of the individuals reading the charges. So reading the charges multiple times to make sure that everybody was understanding of what the charges were. And it was very clear what those charges were.
So were there any specific pieces of the charges that stuck out to you that you just couldn't quite hang your hat on, or where you said you wound up thinking, okay, if we find her guilty of the involuntary manslaughter, then we also probably had to find her guilty of leaving the scene of the accident or death. What was that process like? Or did you talk to the audience, if you will, a little bit about what made you come to that conclusion? What about the language of the charges were you bringing up again in those deliberations, if you will?
In terms of thinking about if the leaving the scene of an accident would be brought up, I have to admit that was only a thought in my mind. I don't know if that was a thought in everybody's minds, but in my mind, if we sway in one direction or the other with the involuntary manslaughter, in my mind, I was thinking to myself that we have to sway on the other charge. Granted, we never signed that charge in that document. Therefore, that's why it was left as a fully hung jury for all three charges. In terms of thinking about or discussing particular pieces of the charge, in terms of manslaughter, we really were stuck on the exact verbiage of what it means to be guilty of involuntary manslaughter while operating a vehicle under the influence of alcohol. So we really read that a lot. And that's the one that we really deliberated on for those many days. The other charges, pretty much, we had come to a conclusion and an agreement that the first charge, which is man two, right, homicide, we clearly said was not the case. And that was a early, easy, unanimous vote of not guilty. The final charge, leaving the scene of an accident, we all arrived at as well that essentially she didn't even know. I don't know if that's necessarily just to say that if you didn't know that you were in an accident, but we felt that there was no accident for the most part. And therefore, again, that was an easy vote for the group. The group deliberated for the longest time and tried to arrive at a conclusion with that second charge, involuntary manslaughter. And it was very, very difficult, even with trying to look at all the evidence. Ultimately, at the end, the individuals were stuck on their beliefs in one direction or the other. And again, I don't know if we were left there for another week or so, if we would have come to any unanimous conclusion.
Were people pretty respectful of each other during the deliberations, even if things were tense? Did anybody ever yell or swear? Was it testy?
I think there was a few times that there was, and I think emotions were high at that towards the end. And there was a lot on our shoulders in terms of the responsibility. Everybody's looking to us to come to a conclusion. And I think it was emotional and somewhat disappointing for some of us, because when we ultimately had to come in there and we were dismissed, there was no closure for Karen and her family, no closure for John and his family, and any other friends and relatives that were there, no closure. And I think that's what we were hoping for, is to at least provide closure to the families. But clearly that wasn't meant to be on that day.
Sure. Yeah. And it's hard. You guys had a job to do, and there was a specific objective that you all had to be unanimous, and what we thought you all had to be unanimous on all three charges at the time. How did it come about that you, after the fact, starting to learn a little bit more about the case, when you're able to actually do some research on your own, did you feel like you had been, oh, what was that experience like?
It was very interesting because at the end, when you're walking out in the real world and you can research everything and you hear what people are talking about, some of us were very much naive when we were told that Chloe was rehomed. So some of us actually thought the dog went to a different, so we were like, why didn't they come in as a witness? And why didn't they talk about this? Turns out that rehomed was rehomed,
Uh,
right? We didn't know that. We didn't, again, I think we were naive on that. Looking back at it, I don't, I think it's very, like I said, very interesting to be from the other side where you have media and you have all these things to be able to come up with a conclusion and an answer. And then also on the opposite side, being part of a jury that is limited in what you have for data and you're only given certain data points and that's it. You can't look up anything on your own. We wanted to look up, one of us were talking about, I don't even know if I go up in an elevator, will it show that I change, right? In terms, do I go up and down the stairs
mm,
or do I only have to go up and down the stairs? If I'm in a car and I go up a hill, will that also show a change in if I go up and down the stairs? Like those are certain things that we talked about. Data in terms of somebody who's really good with GPS location, all of these little pieces of things that we were talking about and said, those are interesting things that we can't look up and
right?
general public can, like anybody can, right? Because you're not restricted. But as the jury or a juror, you are restricted. You're restricted. Good thing, and I don't know if they're going to do this time around, but sequestered the jury, right? Good thing we weren't sequestered, but if we were sequestered, that would be even harder, I think, in terms of physically and emotionally for the jury to have to be sequestered during that specific time frame.
Definitely. And I know someone cried at the end, I think. Did you feel like emotional as well? Or what was that like when you were finally done with your service?
I think we were all very emotional at the end. I think we were relieved that it was over. I think it was emotional because we were thinking with all this time and effort, haven't come to any kind of conclusion and be able to provide any kind of closure for anyone. And I have to admit, disappointing because of the fact that we said we were a hung jury when in fact we could have said, no, we are hung on one charge, but not on two charges and not waste the time and effort and resources of a retrial.
So how and when did you find out, oh, we could have actually deliberated on those two?
There was one of the jurors who was not selected to deliberate was a lawyer, and it was gleaned upon after the fact, probably a few days after, that we realized we should have asked that specific question to the judge because it wasn't clear. Can we ask multiple questions? And will she be mad at us if we ask a question? So I think that was one of the things we're like, it's almost like you're asking the teacher
To
for
go to
an
the
answer.
bathroom.
Yeah, go to the bathroom or answer. And you're like, I don't know. Am I going to get in trouble to go to the bathroom or for
Right.
the answer to the question? So looking back at it, I think we really should have. And I think that led to a little bit of disappointment. So the group was emotional. Some of us were not as much, but I think some of us just hide it well.
Yeah. And it's totally also, I would think, the job of lawyers, the job of the actual system to clearly instruct you all on here's what you're allowed to deliberate on, here's what we need you to be unanimous on, here's what we don't need, and here's what you can ask questions about. And my grandmother always said, doesn't hurt to ask, right? Never hurts to ask, but it's so hard. I would have definitely done the same exact thing as you guys because it's anxiety ridden and it's so emotional. I can't even imagine what it's like to have to hold someone's fate in your hands when they're like right next to you and it's just such a high visibility trial. It's like the OJ trial of Canton. It's huge. Like, I grew up in Canton. I don't know if I shared that as well, and I do. I know of people. I don't have close relationships with anybody involved in the case. Um, and when I say close relationships, I really mean I don't have close relationships like some other people who testified in this case. I'm just kidding. But basically, it's like I have heard people saying he never went in the house. He never went in the house. And I think that's a narrative that's personal because I know these people, like I grew up with these people, but that's also different than what is in the public narrative. That's also different than like what the average juror might think based on people's testimony. So it's super complicated. As you came to realize, oh, we could have done this or we could have done that, how did you go about talking to the other jurors, or how did you go about like coming forward with that insight?
We, so a couple things is we bonded because we were together for such a long time. We took some contact information of each other's, and then we said was, do we want to come together and sign a petition or something? The unfortunate thing is that it's very clear by the letter of the law. It doesn't look good that we're signing a petition after the fact. So if anything, it should have been done while we were still in deliberation, not when we were already dismissed and the case was already led as a jury. So I think that's the problem there. I will admit that I think looking back at it, number one, the group, we all did our best and we all worked at it. And we all participated and we did our due diligence as a jury. In terms of the court officers, I think they were excellent. The group that was escorting us back and forth in terms of the state police did a great job, right? They tried to get us out of there so that media and other people couldn't see and couldn't interfere with us. And also the judge, I think she did an excellent job based on her trying to follow the letter of the law, which how it should be, and not interfering with our deliberations and trying to guide us in terms of which made it look like she was coercing or leading us in one direction or the other. So I think although we verbalize and point out as the group and jurors that we wish that she could have given us more direction, I think by the letter of the law, it would have looked like she was trying to coerce us or lead us in one direction, and it would have been inappropriate legally. So I think in the end, knowing this, and maybe hopefully people glean this information so that if they're ever part of the jury, they are now aware that you are correct. It's never bad to ask a question. And what's the worst that can happen? You're told yes or you're told no, right?
But it's much easier said than done, right?
Correct.
Did you have any opinions on people in the house that night not coming out to be checking to see, hey, where's John? Where's Karen?
I think it's suspicious. So first, I have to admit, if you told me, and I don't know you personally, but if you told me you were coming over, I think I would look for you, especially if you said that you were outside, and make sure that you get ushered, especially if you're not familiar with the territory. I also have to admit that it is very suspicious. Maybe I'm just the nosy neighbor, but if I saw somebody or saw law enforcement outside of my front door and I'm a first responder, I think I would be obligated to at least look outside and go, is everything okay? Do you guys need anything? What's going on? It sounds like I'm nosy, but at the same time, I think it is the responsible thing to do. And in terms of the investigation, that's the other thing that we were sat on. There was no other neighbor testimony on what was going on during that time frame. If there was any screams, any yelling, any other cameras that were directed in that general vicinity, I think those were all kind of things. But yes, the mere fact that nobody came outside and there's cars there, and also nobody kind of recognized that there was somebody there on the front lawn. I think if I was driving down the street, I get it if there was so much snow that I couldn't see. But at the time, it didn't seem like when people were initially leaving that there was that much snow to cover up a body.
What do you think happened to Chloe?
So it was very interesting because again, we were naive. We thought that she was rehomed to a different state. Everybody has now pointed out that rehomed was code for euthanized. And we're like, oh,
That's what
okay.
they tell you, right? I
Right?
don't know.
And especially now that we can't even, I think it's interesting that you can't even follow up and try to find her, right? If she wasn't euthanized, then the current owner, that would be good for testimony or kind of a look at what's her, right, temper and what's her demeanor and how the new owner took her on subsequent to what was going on. Same thing of why was she even rehomed in the first place? I don't think
Mm,
that kind of went into our mind. We were just told that she was rehomed because she was having behavioral issues. So
yeah. What? Sorry, I always laugh about Chloe because it's always so funny. And just not great with strangers and that whole thing always gets me. You talked a little bit about some advice for jurors and taking good notes, maybe flagging things that you think might be important. What about feedback for both sides? Like on the Commonwealth side, what do you think they did well or didn't do well? And for the defense, same thing.
for the prosecution, I think the big deal would be just making sure to have clear charges because ultimately clear charges and clear direction regarding those charges, I think is important so that it makes it easier and facilitates it so that the group can arrive at a conclusion. It would be nice also to have somebody, and it's just the personality thing, but just somebody who maybe speaks up more and doesn't mumble and is also just, I don't know, more personable. I think the defense had a lawyer that presented with a little bit more almost professionalism and clout versus the prosecution did not. And no offense to either group.
Yeah.
Um, the other thing that wasn't, and again, no offense to the prosecution per se, but we did realize that um, the prosecution would be standing outside smoking.
Did you run into them when they were smoking?
We would always pass them by when we were right coming into,
Oh my god.
and
Oh,
yeah, so
cringe.
like little things like
No.
that would have been just a little bit better. But in terms of the case, I think just having somebody who's more eloquent and clear with their speech, because the time it was very interesting because at the very end, when it was closing argument or during cross examination, the prosecution would be very clear now all of a sudden, and it was now they could be
Where
heard.
was this the whole time?
Yeah, where was it
Yeah,
exactly? Yeah.
I gotcha.
And
Yeah,
then in
I'm
terms
sorry.
of the defense, I think it would have been nice to present all of the rebuttal testimony without any kind of confusing evidence. And when I say confusing, I think all of the other things that they were trying to show were potentially distractors to create the impression or the air for the jury to think reasonable doubt. Unfortunately, I think because of all that data, some of the jurors made a conclusion and developed beliefs that they were in for it to just create this kind of distraction and ultimately make it hard to go in one direction versus the other. It would be nice if they were a little bit more, all of the important rebuttals first, and then afterwards rebuttal testimony, and then any of the other additional pieces, like having an expert on animal bites was
Mhm.
great. But the problem is we don't have a dog. So we don't have a dog. So it's hard to tell, like, what are we doing with that? Is that just a distractor? What are we going with that versus are we going to show something with it? Would have been nice.
Yes. And from your EMT experience, have you ever dealt with dog bites, dog scratches, or hit and runs?
Yeah. So definitely been involved in a fair share of pedestrian struck versus a hit and run versus some dog bites or animal bites. They're all very different. I think we discount the fact that this was also in the middle of a blizzard or a snowstorm where it's very cold and pieces of evidence may not have remained, especially if initial collection efforts and preservation of scene was not done well.
Yeah. And along with the pedestrian strikes or the hit and runs that you've dealt with, I guess in this case, we want to focus in on the pedestrian strikes because that's what we're looking at. Did people have missing shoes who were struck in your experience?
Based on the mechanism, they would have either not only missing shoes, but maybe a hat or something thrown because they would be right ejected from where they stood and then ultimately impact something else. During that time frame, though, there would also be injuries consistent with a pedestrian struck. So if you have your shoes torn off, then you would also have bruising and other injuries to your long bones consistent with the impact that caused or that force that caused that
And
to
in John's
occur.
case, there were none specific to the
The
leg
lower
area,
extremities.
yeah, lower
There's no
extremities
injuries
altogether.
to the lower extremities. Again, not consistent with if somebody was impacted. So if somebody was impacted, that would have, and I understand the concept of maybe it's hat and a hat may not, if you could have been thrown and your hat falls off, and that makes more sense. But if your shoe falls off, that's harder, unless, of course, you are wearing flip flops, which is not the case. So it was tied shoes. It wasn't
Mm,
necessarily clogs or flip flops or sandals that could come off. And so that would be, again, harder to not have any kind of injuries to the lower extremity.
yeah, that's a good point. I think just the injuries in and of themselves are just super puzzling.
Inconsistent.
Exactly. Why now? Why are you deciding to come forward now? There was a time when nobody knew any juror's name, nobody knew any juror's face, definitely not. What made you decide, okay, it's time?
I think I did an initial interview with Turtle Boy, but I was blacked out, I think, or I was hidden. And at the time I thought it was fine. It wasn't right. I was providing information, making sure it's come to light again. And I felt more comfortable. I think it's almost a year, not yet, but getting close. And I think these pieces of information are important for the public to know, to understand what actually happened from a juror standpoint, as opposed to speculation and what media was putting together based on what media did for research and information. And I think it's also good to understand for the general public that the justice system does work. Because if you really think about it, if we're saying that she's not guilty, she would have been already convicted now as a direct result. But because it was a jury of 12, clearly there was reasonable doubt, and that's why it was a hung jury.
Do you think that you feel more comfortable looking ahead to the next trial? Do you feel more nervous? How are you feeling in terms of where the case is at? Does that make you scared at all? Or
I honestly think it probably going to be again a waste of time and resources. And I only say that because I think in reality, you have to just think of it as we did our due diligence. It's hard to find a jury that's not going to be biased now, who has either watched some of the Turtle Boy pieces or some of the media, looked up certain things, researched certain things, and will not have some sort of bias. So I feel like it's going to be very interesting in terms of how it's going to pan out for jury selection and then ultimately for a verdict. Again, I believe that it will remain the same for 2 charges. I don't know if it's going to, again, make a difference for that. I think it may be the same result, and it will be interesting to see if it is the same result, where it will go from there.
will you be watching?
I think I will try. I know some people where I was actually working were actually actively watching court TV, and I didn't even realize the court TV was that much detail, that it was watching the whole thing. Yeah.
Looking forward to the future. Do you think you're still going to be stepping into the light a little bit to talk about this case?
I am more than happy to continue
Oh,
to talk about the case because I believe that, again, it will be helpful for future generations. And it's also helpful for some individuals who have unanswered questions about how the jury actually ended up having deliberation and ultimately being on jury.
and what did Auntie Bev just thank you guys for your service at the end? I call her Auntie Bev. Sorry.
Yeah.
Did she thank you for your service at the end, or how did she send you guys on your way at the end?
Yeah, so she actually came into the room and it was very emotional. She thanked us for our service and that we did a really good job given the circumstances of what was going on and everything that was happening. And then sent us really on our way. She said that we could use her name to avoid jury duty in the immediate future, but who knows? 2 years later, might be in a jury again.
Hopefully not for the same trial.
Yeah, hopefully not for the same trial, but